That idea of what litigation is about is completely changed in the name of PIL. So what has happened is that procedure from the mid 70s, late 70s especially, came to be seen by the court itself as the obstacle to justice rather than the means of justice. Now I think it's an idea which infects every part of the legal system. I mean, every aspect, even criminal justice.
Welcome to Ideas of India, a podcast where we examine academic ideas that can propel India forward. My name is Shruti Rajagopalan, and today my guest is Anuj Bhuwania. He's a professor at the Jindal Global Law School, and his recent book, Courting the People, Public Interest Litigation in Post-Emergency India, is an excellent account of the development and failure of the public interest litigation movement. In his book, Anuj details the big PIL cases in the last few decades concerning pollution of the Taj Mahal, of pollution of the river Ganges, as well as cases dealing with vehicular pollution, deindustrialization, and slum demolitions in Delhi. His analysis brings out two implications of the PIL movement on India. One, on Indian citizens, especially the poor, because of arbitrary and draconian orders of the court. And second, the toll the PIL movement has taken on the Indian judiciary and its reputation. I had a chance to speak with Anuj about the relaxation of locus standi requirements and procedural constraints on the judiciary in India since 1980s, about the current state of the Supreme Court, ruled more by whim than by law, the work of a legal anthropologist, his intellectual influences, and much more. This conversation was recorded before the Prashant Bhushan contempt of court case. But Anuj's ideas and research also help explain these recent trends in the Indian judiciary. For a full transcript of this conversation, including helpful links of all the references mentioned, click the link in the show notes or visit mercatus.org/bridge. Hi Anuj, welcome to the show.
Hi Shruti, thank you for inviting me. It's a pleasure to be here.
The book is a great mix of constitutional jurisprudence, especially the PIL jurisprudence that's developed post-emergency in India. It's got a great mix of empirical work because you track four cases, big PIL cases of our times, which is the Taj pollution case, the Ganges pollution case, the Delhi vehicular pollution case, and then a case that has no name or many names, the deindustrialization of Delhi. You have sort of tracked these cases. They were not the usual cases where, there is a plaintiff and a defendant, and they have arguments before the court, and then there's an opinion. These cases were really series of orders, most of them continuing mandamus orders issued by the court, where the court was sort of governing from the bench. Right. So can you tell me a little bit about these cases and what piqued your interest in them, and then how you tracked them?
What legal academics really do is analyze judgments. Besides, just to put it very crudely, of course, they do a bunch of stuff, but that's what our bread and butter really is. And ordinarily, when you study something like PIL, you'd be analyzing judgments, and so that would be a raw material with which we work. But what I quickly realized when doing my fieldwork is that that's actually not a very useful way to study this jurisdiction, because this is jurisdiction which increasingly does not result in the traditional petition, litigation, judgment form. It continues for years, decades in many of these instances. The petition, as I realized, has very little to do with what actually happens in the case very often, because we'll talk about that. And the judgment, of course, sometimes never happens. There's no such thing as a final judgment in many, because some of these cases never end. Some of the cases that I talked about are still going on. It's been more than 3 decades. Some of them started in 1985. It's 35 years now. The most well-known case being the Forest case, started in 95. It's heard every week for almost 25 years now. So these are not traditional, what we studied in law school as judgment. So that they would not really help us understand, in my view, adequately what this object or PIL is.
So if I may, can you tell us the journey of one of these cases and how you tracked it, so that we get to know more about how a legal anthropologist really works in terms of collecting field research? And, we would also learn a little bit more about the cases.
I have to get a little autobiographical here. So I went to law school in the late 90s, where, of course, I was exposed to public interest litigation as a probably India's greatest gift to global jurisprudence as something to be particularly celebrated, a unique jurisdiction that arose in India. And I, in fact, interned with Prashant Bhushan, who's probably India's most well-known PIL lawyer. And, I, like most law students, had a very high opinion of what PIL really does. Over the years when I was in UK and US, I would hear about strange things happening through PIL, a lot of slum demolitions, cycle showers being barred in Old Delhi, which is a very strange thing to do. So I would hear about strange orders, but it would still feel like, well, the court has become neoliberal or some such, ready explanation that I had in my mind. But when I came for fieldwork, I actually got exposed to it very differently. I had a friend who used to live in a slum settlement near Delhi University, Dimarpur area. That settlement suddenly got a demolition notice citing a particular writ petition in which there was supposedly an order in which the particular settlement was to be demolished. Except nobody in the settlement had ever even heard about the case. She asked me to help. So I actually started in that way. So I tried to find out more about the case. That turned out to be the case which is called Kalyan Sanstha, which is the case I talk much more about in chapter 3 of my book on PIL as a slum demolition machine. So I was trying to understand how is it that an order can be given for demolition of a slum where these people are not even parties to the case. So then from there onwards, I started trying to understand what this case was about, its history. I tried to file along with a bunch of other friends, write to information requests to get more information about this particular process, this particular case. Spent a lot of time in municipal offices to understand what are they up to, because it was being done through Municipal Corporation of Delhi, the assistant engineer of that particular area. And then I started looking at the case. I started attending hearings. This used to happen at the time every Wednesday afternoon in Delhi High Court, where this case was being heard. Now, this case, once I started following it, I realized this is nothing like what I've studied in law school. This is not a case like where there is a petitioner, there is a respondent, and this is something else. The hearings for this case used to happen at the time the Chief Justice's Court in Delhi High Court, which is a pretty large room. I mean, probably around 150 to 200 people could be accommodated there, and that would be so full for just hearing this case, but that there would not be space to enter. So there was something strange going on. This case actually was suddenly resurrected in 2003 through PIL writ petition being filed for in the name of an organization called Kalyan Sanstha, which nobody has heard of since before or after, with regard to illegal constructions in the city of Delhi. It is an open-ended case which sought to revive another PIL from the 80s, about 15 years prior to that, from an area called Patel Nagar in West Delhi, where there were apparently illegal construction in a very specific part of Patel Nagar. In fact, 2 particular buildings are mentioned there. So from that one specific judgment on a very specific area of Delhi, this case came up 15 years later about illegal construction in Delhi in general. Now, at that point, this is a complicated story. At that point, there were quite a few cases already pending in Delhi High Court, which related to illegal constructions in various parts of Delhi. What the then acting Chief Justice at the time did, he combined all of those cases and he said all of them have to be heard through this case. And through this case, then, what he did was that he said that all cases related to illegal construction will be heard through this case. And he divided all of Delhi into 12 municipal zones, appointed a court commissioner for each municipal zone, appointed what he called the monitoring committee, which would monitor illegal constructions throughout the city. And what would happen was that advertisements would be issued in newspapers, etc., where it would be notified that anybody noticing anything which is occupation of public land or misuse of public property, meaning that violation of zoning laws, etc., could just call the court commissioner, who court said would be paid a certain amount, and that court commissioner would inform the monitoring committee. So what would happen is that the monitoring committee would then ask the municipal authority just go on and demolish that particular settlement. This was what I call the perfection of the slum demolition machine that the court had become at that point. So in that decade, on the first decade of the 21st century, about 1 million people were evicted in Delhi alone through such cases, and this particular case being the largest of them all.
So what is incredible about what you're telling me is this is a case where the people living in the slums never took any action. they were not party to the suit. Usually the, MCD, Municipal Corporation of Delhi, or NDMC, which is the other union government municipal authority, are not the ones initiating the suit against any kind of illegal settlement. It is the court which has decided to govern and create policy from the bench. So it's taken on a legislative duty on guidelines about what is legal or illegal construction, and then also executive authority in the sense that it has appointed a sort of extra legal commissioner, so to say, who is not part of MCD in any way and is its own authority. And any person who has nothing to do with the original illegality, is not a neighbor, is not affected by the illegal construction, can just call in, and the suit will continue endlessly and it'll be heard every Wednesday in the Delhi High Court for about 3 decades. Is that a good summary of what's happening?
So this case didn't last luckily that long. This case actually, the particular avatar that I described actually went on in 2004, 2009. But enough damage was
so only 5 years.
Only 5 years, but that was by the standards of PIL that
it's short.
It's short actually, but they did quite a bit of damage in that period. But what I realized was that while of course I could talk about the politics of slums in India, and that could be one way of looking at these kinds of cases. What I realized was this is actually, of course, that aspect is important. The politics of urban development and urban poverty and housing, etc. But what I realized is this is something specific about the court itself. It is not, of course, the court had a particular bias and the court had a particular predilection, but it was about the fact that the court could be maneuvered in such a way. The court could actually maneuver itself in such powers, with such powers. Itself was unique. So therefore, then, while initially my work was about following a whole bunch of cases around slum demolitions, eventually I realized that it was about PIL per se. It was not about PIL on. So a lot of PIL related studies have been on gender related PILs or labor related PILs
or environment related PILs. No, it's great you mentioned this because I got a similar sense from the book. You track these 4 stories. All 4 of them have some environmental content, right? The slum demolition is a particularly egregious case of sort of coming down hard on the poor who have no choice but to live in illegal settlements. But mostly they are contained, within a certain purview, which is the environmental regulation in Delhi. But what emerges from your analysis is startling because it's not about the subject matter. It is not about the specific content of the law or its illegality. It's more generally about how the court thinks of procedure and how the court specifically thinks about procedural constraints on itself. Right. And, any procedural constraints that tie the court's hands through the PIL system over a period of, a few decades, the court has managed to completely come out of any binding constraints or any procedure it needs to follow. And it's sort of a bit of a dictatorship in the sense, right? It does precisely what it wants. And individual judges become petty local dictators in that particular area of law. And I don't even want to call it an area of law. It's really that particular area of governance. Right. Because they're really governing. Yeah. Do you think that's a fair assessment of what has come out of this work? The lack of proceduralism is at the root of this?
Absolutely. That's definitely at the root of it. In fact, so when we study PIL in general, when we studied I studied in law school, the defining aspect of it would be the relaxation of standing, would be that the locus standi question has been relaxed. But that is actually just the beginning of what PIL entails. It's really, there's a particular quote that the Supreme Court and High Courts have repeatedly used. They say that procedure is but a handmaid to justice and not its mistress. There's a strange line which they love quoting, but that really is where what the court thinks about procedure and has thought about in the last 4 decades. This particular line became commonly used, especially from the mid-70s. Now, like I said, I was a criminal lawyer for a brief while, but that formed a new common sense for me about how to think about procedure. And any criminal lawyer will tell you that procedure is everything. And for me, that was this was astonishing. That the court could do that. So this was really not adjudication as we think of it, what common law adjudication is about. So then it started with standing, became about everything. So for instance, evidentiary standards could be relaxed, sometimes for good reasons, of course, but once that practice became common, it led to devastating results, and the cases could continue forever. All the aspects, the beginning, middle, and end of a litigation. There was this line of Jean-Luc Godard that he thinks that films should have beginning, middle, and the end, but not in that order. Supreme Court is something along. So that idea of what litigation is about is completely changed in the name of PI. So what has happened is that procedure from the mid 70s. Late 70s especially, came to be seen by the court itself as the obstacle to justice rather than the means of justice. Now I think it's an idea which infects every part of the legal system. I mean, every aspect, even criminal justice, which is where one would think it wouldn't be happening. But recently, the court gave judgments on a case related to rights of the accused, where they happily use this same procedure for a handmaiden justice. And of course, in civil procedure cases and in general, what has happened is, as you said, fidelity to law itself came to be seen as a strange kind of encumbrance on the court. I mean, the court no longer thought law itself as limiting its powers, really, especially the appellate courts in India.
You've pointed out that standing, or the relaxation of locus standi requirements, that was sort of the beginning of the PIL story, though it has expanded beyond it.
Right.
So if I understand correctly, originally standing was relaxed in cases like Badhua Mukti Morcha, where the idea was that normally standing is an excellent common law rule because only people who are stakeholders, directly affected, have skin in the game, should be parties to a suit. Mm-hmm. But in a country like India, which has the kind of poverty, inequality, and poor access to justice, a really important way of addressing that is to relax standing.
Sure.
So the sort of poster boy case is Badhua Mukti Morcha, which is a case on bonded laborers.
Right.
And by the very nature of the suit, which is this is, modern time slavery, or at the very least indentured servitude, they are not in a position to challenge the system and access usual means of justice.
Right.
And therefore, the standing requirements must be relaxed.
Right.
Now, of course, what has happened is it's infected everything, as you mentioned. And very often what you see in the court is people who have nothing to do with the suit file a case. Usually the parties affected, like those living in slums, don't even know that there is a case going on which affects their very life and where they live and so on and so forth.
Right.
And additionally, you can have parties getting attached to the suit at various points in the life of a case or a series of orders. So there's also this expansion, right? As you go along and as the court gives orders, more and more people may sort of step out of the woodwork and start getting attached to the case.
Absolutely.
And this has some very serious implications for how we do jurisprudence as a country, right?
Absolutely.
Because as you said, it has no beginning, no middle, no end.
Yeah.
So one of the, I think, bad outcomes of standing and having anyone come to court, I think the worst example of this is the Kaushal case.
Absolutely. Yeah.
Which overturned Nas Foundation.
Right,
And as far as I know, Kaushal, who was the astrologer who decided to appeal the Nas Foundation case, it was a case where the Delhi High Court had held Section 377 unconstitutional. So Nas Foundation won the case.
Right.
And the government decided not to appeal. Right? So in an ordinary world, matters would have ended there.
Right.
And then Kaushal, who was not party to the initial suit, came up and challenged it in the Supreme Court.
Yeah.
And the Supreme Court heard this case that I think it had no business entertaining. And then it overturned the Delhi High Court judgment. And it sort of delayed, what happened to LGBTQ rights and their dignity by at least 5 to 10 years as a consequence of this kind of weakening of standing.
Yeah.
So do you think that's a fair assessment, that weakening locus standi requirements and procedural requirements has had a very big impact on how we deliver substantive justice in terms of right to life and right to dignity and right to equal protection of the law?
So, Kaushal case is a good example, of course, as you rightly said, that this person who had nothing to do with the High Court case suddenly comes up, files an appeal when he is not even a party. But so I'll have to give a slightly longer answer to that. Now, relaxation of standing per se is not a bad idea. So Article 32, under which the Indian Constitution allows people to approach the Supreme Court directly, could be interpreted in a way that there's some kind of relaxation of standing would be possible. But as Clark Cunningham wrote about it, almost 3 decades back, this is an American legal academic studying PIL in India, there are at least 2 ways of thinking about it. What he calls representation standing and citizen standing. Representation standing would be, some kind of a class action. There would be some particular organization or some kind of a group coming together who would directly have some link with the people directly affected, who had so it wouldn't be some random person who has nothing to do with the person's concern, with the people who are affected by the litigation. Citizen standing, on the other hand, is you approaching the court as a citizen with regard to any issue. I feel like India has a problem with regard to pollution or anything, and just going to court with regard to, without any direct relation except as a citizen. Now, what has happened is that while relaxation of locus standi could have been based on representative standing, and in initial some cases they were, what has happened is that the court has thrown the baby with the bathwater and removed any such constraints on standing. And as a result, like you said, anybody can go to court with regard to anything, and the court doesn't see that as a problem really, except when it wants to, which sometimes it does. So that's another aspect of that. But Bandha Mukti Morcha is an interesting case, and of course there it's literally the Bandha Mukti Morcha, meaning a campaign for bonded laborers. And obviously that organization, nobody doubts its bona fides with regard to representing the interests of this particularly poor section of the Indian populace. But what was happening in that case was another aspect of it was a problem which has led to enduring problems for the process. In fact, this is a good example of the old adage of hard cases making bad law. So this case, interestingly, was mentioned to me as precedent when I interviewed one of the court commissioners in the Kalyan Sanstha case, where when I asked him, how can you take order demolitions without any process, where is the evidence that you marshal to make a case for demolition? It's a pretty drastic action you're taking. He said, well, in Bandha Mukti Morcha, the court had created an evidence gathering entity which of its own, it refused to go by evidentiary standards. So what happened in that case was that the court appointed a social legal commission, what it called, and who alleged, found that there were widespread cases of this illegal activity of bonded labor. The state government of the time said that, well, they denied this, and they said that there had to be standards by which this particular report which they have submitted, the Social Legal Commission, has to be cross-examined. There has to be some way of interrogating that. And the court said, well, procedure is but a handmaiden justice. So what it did was that it said that we don't have to, as Justice Bhagwati, who was the most famous PIL judge, who would claim that he created PIL and who is the principal person behind all of this entire PIL process, or the lack of it. He would say that, well, PIL means that we don't have to go by those standards. So what has happened is that this is another example of ways in which allegations are treated as fact. So many of the slum demolition cases, parties would go to court, middle class organizations would go to court with pictures of slums, defecation in public, as well as people having televisions in their slums, and they would say, look at these people, they're actually affluent and they're living and they're causing such nuisance, and the court would just accept it as gospel without interrogating. So what we are seeing is really that there were ways in which the court could have relaxed standing. Under civil procedure, there is a process called of appointing court commissioners in situations. The court could have extrapolated from that. The court could have tried to work with some rules, even if liberalized ones. What the court instead chose was to work with no rules.
Yes.
So that is the problem, that the court decided to create something based with no base.
So it's not that the procedure is faulty.
Yeah.
It's that there is no procedure.
Exactly.
There's no consistent application of a single kind of procedure.
Absolutely.
And it's not like they created a rule book where PILs are treated differently from regular cases. There is no rule book.
Yeah. So whenever they've created, in fact, in the 80s, there was a kind of attempt by some Supreme Court judges to resist this tendency, and they actually suggested that the rules should be framed. There was litigation also around, but they never led to fruition. The court just has refused to limit itself in any way with regard to rules. So,
There are a few different ways of thinking about this pattern. So one is that the court has moved from an adversarial system to an inquisitorial system. And it has done this without any legislative or constitutional backing. The worst version of that is court taking suo motu cognizance of a particular issue. But even cases where there is a petitioner and a respondent, they convert the adversarial question into an inquisitorial question because now the court assumes that it represents the interests of all parties in all matters in all of India. So do you think that is a structural change that the PIL has caused?
Yeah. So in PIL, what happens is that ordinarily, as we know, the PIL is a writ petition, and ordinarily there would be a person approaching the court with a petition alleging facts. What has happened is that the court has interpreted the PIL petitioner as just a crutch to bring to its notice certain allegations. And then, in fact, in the first chapter of the book, I talk about the curious case of the disappearing public interest petitioner, because there are so many instances in which the court would just treat the petitioner as just an informant. Police investigation starts with an FIR. So if I see some violent activity happening, for instance, illegal activity happening, criminal activity happening, I would go to the police and bring it to their attention. I'm not a party per se. Yeah. I'm just an informant. Yeah. That's what they've reduced the PIL petitioner to. Yeah. So what happens then is that even when there's a party which is actually not a lot more than an informant. See, there are many instances where they are actually just informants, but there are quite a few instances where, party is directly affected or party is particularly well versed. The court still treats them like that, and the court just and often then the court just takes the case into whatever direction they deem fit. And this is a recent one which happened last year, much after after the book came out, was a case filed by Harsh Mandar last year with regard to the detention centers in Assam. This is a very controversial thing happening in India where people who were not who didn't find themselves in the National Register of Citizens in Assam, or were called doubtful voters, were deemed to be illegal, deemed to be foreigners.
Illegal immigrants. Foreigners, yeah.
Exactly. And kept in detention centers. So with regard to the condition of detention centers, Harsh Mandar last year, in 2019, filed a PIL in the Supreme Court. The court instead decided that actually the problem was that there were not enough illegal immigrants being deported to Bangladesh, rather than the problem of the conditional detention. So in fact, their concern was exactly the opposite of the petitioner. And this has happened, by the way, in many, many instances since then.
So it's just an excuse to basically take cognizance of a larger matter and then govern from the bench to create policy on whatever broad area that they wish.
Right. And in fact, in ways which are completely contrary to the petitioner's contentions. And in the court, in a sense, expropriates the petition and takes it in whatever way it deems fit. And it's been doing it for decades now.
So there are some reasons why the PIL became as popular as it did.
Right.
And I think one of the most important reasons is a weak state capacity of the executive. Mm-hmm. I also, like you, followed the PIL trends in the 90s. The cases that you're talking about, the Delhi vehicular pollution case and so on, mm-hmm. I experienced it as a young student in Delhi when suddenly the bus fleet just disappeared and you couldn't get an auto rickshaw for weeks on end, and there were all these shortages. And I sort of lived and experienced that firsthand.
Yeah.
And one reason why people were willing to tolerate it is because they felt that the executive was just simply not paying attention. Right? So executive inaction in any matter was used as the reason to tolerate judicial activism. And in some sense, it's not clear that the average citizen understood the damage being done by relaxing all the procedural constraints.
Right.
But they were willing to live with it because they said at least someone is doing the right thing in terms of protecting the Delhi rich forest or reducing pollution, which causes high levels of morbidity and mortality in Delhi, and so on. So we were willing to live with it.
Right.
So now it seems like that legitimacy has been lost, that the Supreme Court had won so hard. So the political legitimacy that can only come from the citizen has been lost because it has gone in directions which are very arbitrary and just seem to be very self-serving.
Right. I'm not sure the legitimacy has been lost, but to return to what you were saying earlier, it's definitely true that PIL has captured the imagination of the people in a way that almost no judicial proceedings in India. So Indian judiciary in general there's a particularly low opinion that people have of it. The irony is this kind of schizophrenic view that people have of the courts, that the lower courts are pure pathology, and the appellate court, especially PIL, is like pure panacea. They are the solutions to all of country's problems. The initial writings around it, that anybody could send a postcard directly to court, definitely has captured the imagination of the people. In fact, it's amazing how many Bollywood movies feature PIL, increasingly so. So yeah, it's almost like the angry young man of the 70s, the late 70s, like the vigilante cop or the vigilante hero. So that's that idea of, well, nothing is being done, something is being done, somebody is there to take these, nobody has any guts except for the court to do these big actions. But that is the logic of demonetization as well, as we know. So of course, the vehicular pollution case is a very good example. This was a case which spectacularly changed the transport structure in Delhi in the late 90s, where suddenly all public transport vehicles had to move from diesel to compressed natural gas. That was seemingly the solution to Delhi's pollution problem. And it seemed like that for a while. So this was, of course, a completely draconian measure. The only vehicles which had to change their fuel were public transport vehicles. So public transport took a beating in Delhi at the time, which it has still not recovered from. In absolute numbers, not even relative terms, in absolute numbers, there were more buses in the late 90s in Delhi than there are now. Auto rickshaws, which the common man's mode of transport, very widely used in Delhi, suffered massively, which led to the fact that most auto rickshaw drivers could no longer afford to own their own rickshaw. So what I'm trying to say is that so at that time it seemed like a good idea. I mean that there was a perceptible drop in pollution in Delhi after the move to CNG in public transport. But look what happened 10 years later. So there's two aspects to it. One is that these people who are directly affected, that is the people who operate and run and people who these public transport vehicles, were very, very badly affected, as well as people who use this public transport were badly affected, leading to a move towards private transport in a big way. And the second aspect, it wasn't really a solution actually. 10 years later, what we see is that the sheer number in terms of expansion of private transport has taken a toll. There's no solution in sight anymore. So what happens is this kind of undemocratic, or not just undemocratic. Judicial action doesn't have to be democratic in the sense that political action has to weigh its pros and cons, but not even listening to the affected parties, which is what PIL process is about. So these people who these auto rickshaw unions, etc., were not even properly heard.
Yes,
they're not even given a voice in this.
Yeah, and one is a matter of representation, right? So it is a question of whether anything comes out of it or not.
Right.
They must be heard because they're very important stakeholders in this policy.
Right.
But there is another aspect. Were you to hear these stakeholders, your cost-benefit analysis might change.
Absolutely.
Right?
Absolutely.
Which is why we leave some of these things to the legislator in terms of aggregating preferences.
Right.
So in the case of air pollution in Delhi, there's very clearly a cost and benefit associated with it. Mm-hmm. None of us likes the idea of pollution, but there is no pollution when there is no economic activity. So as a society and as an economy, we decide that we're going to lie somewhere on that trade-off between willing to live with a little bit of pollution for greater economic activity. And the court chose one end of that trade-off, I believe, incorrectly.
Yeah.
And they chose one end of this trade-off precisely because they didn't truly understand the nature of the trade-off. And they didn't truly understand the nature of the trade-off because they did not hear all the relevant parties.
Absolutely.
Right?
Absolutely.
So the legislature's inaction in some of these cases may simply be, one explanation is the legislature is just asleep at the wheel. Another explanation is these are not easy problems to resolve.
Totally.
And it does take time to formulate a good pollution policy. And we do have to worry about poor people's transport. There's an allocative aspect to this. There's a distributive aspect to this. And we do have to worry about who pays the congestion tax. So in that sense, it seems like the court is not a very good platform for policy making of this sort, despite its best intentions,
right,
simply because it does not have any kind of procedural foundation which can accommodate and analyze these costs and benefits.
Totally. I completely see your point. Let's assume that the court has the best interest at heart. Let's assume that the court really wants to solve the problems that it's trying to address. First, so let's talk about the manufacturing question. Now, the entire change in the deindustrialization of Delhi happened really through one case. The cause of action kept changing multiple times. It started in 85 and it continues to still be there. I call it a many-headed hydra, or a case with 9 lives. Just to get to the point of manufacturing. Now, in the 90s, the court actually ordered the closure of what they call hazardous industries. In 96, Delhi has never been a particularly big manufacturing hub, unlike, let's say, Bombay or Ahmedabad or Coimbatore. Delhi has had, of course, manufacturing, a significant one, but nothing of that scale. Anyhow, so there were some important units, especially in West Delhi area, which the court ordered the closure of. But it led to more than 100,000 laborers who had regular jobs suddenly becoming jobless. And the court never really gave them, avenue to address their issues at all. And the manufacturers actually benefited because they were able to sell that industrial land as real estate, as commercial property. 3 years later, in the same case, the court ordered the closure of what called non-conforming industries, which are basically manufacturing units which are in areas which are not deemed to be manufacturing as per zoning laws. This is some imagination of the city of Delhi that the court has, that zoning laws are being complied with. Now, zoning, anybody who's seen Indian cities would know that it's not a reality that corresponds to on the ground at all to the imagination. And what has led to this order of closing of non-conforming industries? We're talking about small-scale manufacturing units, which were many hundreds of thousands, literally, in terms of units itself, and the number of people who were employed. Probably, we're talking about at least 500,000 people. So these are massive numbers who suddenly didn't have a job. So the deindustrialization of Delhi happening through this, and without these people who are directly affected being in any way made a party to the process. This is all happening in the name of pollution, by the way. So this is just one aspect of Delhi, we know now in 2020 is one of the most polluted cities in the world, and the court has been at it for 35 years. It has actually compounded the problem, in my view. So manufacturing is one, transport is another. We just talked about it. It never really, in fact, it's been directly complicit in destroying public transport in Delhi. It's never really, the public transport in Delhi has never recovered from the court's interventions.
Yeah, it's created 20 cars instead of every single bus because it just killed the public bus fleet.
Absolutely. The slum problem, again, the court, of course, they took this drastic action of taking these eyesores, as many like to call it, of slums outside. But what has it led to? So again, the court has, it has made people homeless in literally millions. So we are talking about we can say, of course, that it has been anti-poor in all of these. That's what's common. But at the same time, what is also common to all of these is the court has actually not made directly affected parties party to the process. So, in civil procedure, there's an old-fashioned but big key doctrine, basic doctrine of necessary and proper parties.
Yes.
That is, you have to hear parties who are necessary to the case before adjudicating on them. I mean, during the adjudication of the case, the court never heard these people. We can say it's a technical procedural point, but it's an absolutely key point. This is not adjudication if it doesn't really hear the necessary proper parties.
Nor is it governance. Because the
Absolutely.
Key aspect of legislative and executive governance is that they take the trouble to represent the people as elected representatives.
Totally.
And, I know the democratic process is not perfect. I mean, in public choice, we have all the issues of, the rationally ill-informed voter and the self-interested political actors, and then, various rules of first past the post which affect the outcome. Mm-hmm. But in some sense, there is still some kind of political representation going on of all parties concerned,
right?
Which simply doesn't exist with the judicial system. Now, I want to step away from your charitable view for a second. A few moments ago, you said, let's assume that the court has the best interest at heart. And I know why you said that. It is to make the larger point of, even with the best of intentions, what happens when we relax procedural requirements. Now, I want to step to the next level problem, which is, in one sense, relaxing these procedural constraints and making the court all-powerful has it in any way changed the way the court behaves, in that it is way more self-serving than it ever was? When you are not allowed to take suo motu cognizance, or you actually need to have parties to the petition and you need to hear them, when you can't relax standing, in a sense, your power is reduced, right? Because you got to follow the rule book.
Right.
Now that all those standards have been relaxed, it seems like the court can do, or individual judges can do, a lot more to serve their own interests. Do you think that's a fair assessment of what is going on?
Absolutely. Think about rules is that they also limit the court. And the court has to be accountable with regard to certain standards which have been set in rules, statutes or the constitution, etc. Now, what has happened in the last 4 decades now is that the court doesn't see itself limited by any such thing anymore. This is with regard to, of course, PIL was the start of it, and but it's now with regard to anything, with regard to criminal cases, civil cases, family law cases. It's not. So recently there's a study by Raisa Vakil on the Supreme Court's jurisdiction we're talking about. There are provisions in the Constitution which prescribe its review powers, which talk about its contempt powers, etc. And she talks about how almost in all of these aspects the court has gone way beyond it. The court doesn't see itself as limited by the Constitution. The court sees itself as above the Constitution itself.
Yes.
So that's a remarkable thing for the court to do with the Constitution. So if that is its view, the Constitution, you can imagine what it does to statutes. This is actually related to the kind of attack on the legitimacy of the Indian judiciary in the mid-70s, led by Mrs. Indira Gandhi, who was highly popular prime minister elected in 1971 under a massive mandate, and the portrayal of the Indian judiciary as this elitist institution with the colonial heritage, and which is not sufficiently Indian, led to this. I mean, it led to a lot of things, and this churning of the 70s what has led to. But the idea was that we have to move away from this formalism of this Anglo-American tradition, and we have to move to something more Indian, which is informal. So this kind of indigenist argument was being made, which PIL actually was very much part of. But there were the other aspects to it, the so-called people's courts or lok adalats, tribunalization, again, which she herself was instrumental in pushing. But this is, of course, a long genealogy that I'm talking about. But what it has led to is that the court started seeing itself in a very different light. The court no longer was interested in procedural justice. It saw itself as being able to deliver substantive justice. The court was going much beyond what a traditional common law code is supposed to do. And PIL just opened the floodgates.
And now it delivers neither. It neither delivers procedural justice nor substantive justice.
Yeah.
If one is to take seriously your concern about 500,000 people suddenly out of a job, hundreds of thousands of people suddenly out of a home, and so on.
Right.
So it's neither managed to deliver the old socialist idea of speaking for the regular person or the poor person in a substantive way, giving them positive entitlements, nor has it upheld the old formalism of, the Kanya court or something like that.
Right. Certainly procedure is out of the way. The court has a fair amount of contempt for it. But substantive justice is a complicated thing. I mean, for a lot of people, this might be actually okay, for a lot of people, substantive justice is a matter of interpretation, right? For a lot of people, they don't particularly, this might be costs that are okay for the states, for a less polluted city or for a cleaner city. I don't subscribe to that view.
Yes.
But substantive justice is one of those things which is a completely
There's
subjective,
no single definition.
Absolutely.
And it depends on who is the affected or the injured party.
Absolutely.
So that's actually a great point that you raise. And this is where I think a little bit of the history and the ideology comes in. In large part, the populist support was with Mrs. Gandhi because she stood for socialism. Right? And Garibi Hatao and speaking for the poor man. Mm-hmm. Right? And what was getting in the way of taking away privy purses or overnight nationalizing banks and taking away things from the rich to redistribute to the poor? It was the constitution and the legal formalism of the court. So in one sense, the balance was tipped where Mrs. Gandhi could get away with a lot of things, even though she did not follow democratic procedure, because it seemed like she's the true representative of the people. And in part, Justice P.N. Bhagwati, Justice Krishna Iyer, who were also of socialist leanings, thought it is time for the court to reclaim and refashion itself from an ideologically neutral position to a position where it does espouse a populist ideology and start taking cognizance of those cases.
Absolutely.
So, as an anthropologist, how much do you think the court has moved away from its original ideology? My interpretation of the court as it works today is not that it is socialist, but that it is middle-class elitist.
Right.
That's my perhaps uncharitable view. But the kinds of situations that the court takes cognizance of is in posh Delhi areas, we shouldn't have an illegal settlement, or we should not have beggars begging on the street, right? These are the sorts of cases that the judges of today are perturbed by, whereas the judges of the 70s and the 80s were perturbed by the situation of slum dwellers in Olga Tellis or Bandhuwa Bhukti Morcha, which is, bonded laborers and children who couldn't represent themselves. Child trafficking, human trafficking, those were the sorts of cases then.
Right.
And now the cases are, let's get rid of the public bus service.
Right.
And let's get rid of the eyesore of beggars begging, on Tilak Marg.
Right.
Right? So do you think the ideological slippage or the ideological shift, it's a coincidence and it's just led to a particular kind of bad outcomes, or this was just inevitable?
Yeah. So there's been a lot of writing on these kinds of seemingly anti-poor concerns of the court, and there's been analysis of what Professor Upendra Bakshi would call the structural adjustment of judicial activism, or the kind of neoliberal turn, etc. Now, this is perhaps arguably valid. I'm not arguing against, but I think what's perhaps more interesting is that the court could become such an important instrument to make this happen. It seems like the concerns have changed, but that's logic of populism. Mrs. Gandhi, who fought elections, famously Garibi Hatao, and question of poverty, this is the most famous aspect of her victory in 71. The concern became a population. You moved from poverty to population. Mrs. Gandhi was, of course, a great populist, but so is our current Prime Minister. His concerns are very different. So populism is an inherently unstable phenomenon, where the concerns can change. The story usually that's said about PIL is that in the 80s the cases were about poverty. In the 90s they were about environment, and from 2000 onwards it's really about good governance. And perhaps there's a logic to this. But to my mind, what is remarkable is that the court current populist mode enables whatever its hobby horse may be, and often it's a kind of a hybrid mixture of all of these. So therefore, for me, the concern is really of the kind of procedural move the court is making, and tomorrow the concerns may be different. So the kinds of cases that are heard now could be about national anthems. So you could argue maybe now it's a more nationalistic phase based on what's the current currency of the country, what's currently popular in the country.
And as the tide ebbs and flows, it's going to bring different kinds of waves of cases.
Right.
And we simply cannot control that. And that has very little to do with the ideology of the judges or the petitioners,
right,
and far more to do with the fact that there is no procedure and there is no rule book. So one other question regarding the design of the court, and this also has something to do with the lowering standing requirements that we discussed previously. My argument while studying these processes has been that interest groups have managed to capture the court.
Right.
Right. And when I say interest groups, I'm very agnostic to which interest group. It could be the environmental lobby. It could be the Delhi middle class lobby that would like less congestion, right? But my argument is that interest groups lobby for action in any democratic process.
Yeah.
What motivates interest group is that particular issue, but their actions are constrained by costs and benefits, right? And one consequence of the judiciary reducing standing requirements has been that it has reduced the cost or the barrier to entry to approach the court for a rule change, which makes it much easier for interest groups to capture the court, or rather capture policy through the courts instead of capturing policy through the legislature.
Absolutely.
But do you see interest group capture of the courts as we have gone on this public interest litigation journey?
Yeah, so absolutely. So entry barriers being relaxed is remarkably, I mean, it's so true that it's the easiest thing to file a PIL on anything. Especially, of course, access to Delhi is important because it centralizes the system. And you're right. I mean, as you earlier said also about all of these aspects that we discussed, no government can ignore the many interest groups which are, who are affected by the policymaking process on all of these issues. There may be slum dwellers, there may be builders, there may be, various kinds of interest groups. But the court can actually do that. So that's one important difference between the court and as you said, arguably it would be very difficult for any democratically elected government to evict 1 million people or to, only time it happened was during the emergency, which is not a coincidence.
Yeah.
I do think that, there's this old argument by by philosopher called Lon Fuller on polycentricity of issues. That adjudication is ill-suited to polycentric issues. For instance, pollution, which in Delhi, which is obviously so many aspects. With the court decides to bracket some of these aspects and just bulldozes his way through literally in many instances. Now, I believe that however flawed the democratic system in India, certainly it has massive flaws, and however many problems we have on these issues, I think the judicial system is probably even more creates more problems than it solves in many instances. And I think one should be very, very careful.
So according to me, as you rightly pointed out, interest group politics is going to have some positive effects in some cases because of reducing barriers to entry, some negative cases, right? Same with PIL.
Right.
Some people might think that Delhi has become actually cleaner and greener. Some people might think the cost we paid for it in terms of human lives and livelihood is very high. Mm-hmm. But I think there is a hidden cost to the PIL structure in general, which is really harming the Indian society, which is different from on a case-by-case basis. Mm-hmm. Because the judiciary has decided to constitute a couple of benches, and I believe Mondays and Fridays are now reserved for PILs in the Supreme Court, similarly in Delhi High Court. They are not hearing as many of the regular cases as the court would. So I guess what I'm saying is, like executive and legislative state capacity, judicial capacity is also a limited resource.
Yeah.
And they are devoting a massive amount of this limited resource towards PIL and governance.
Right.
But in the process, regular cases don't get heard. I think the worst instance of this is the postponing of the habeas corpus petitions that came out of Kashmir.
Right.
And then they were sent back to the High Court. Simply because the court said, we don't have time to hear these matters.
Right.
But instead of hearing habeas corpus, which according to me is the most important constitutional mandate of any court, they're listening to slum cases every Wednesday for years on end. Mm-hmm. And so this has a different kind of unintended effect on the delivery of substantive justice within the Indian legal system, either in terms of pendency of cases, but also in terms of it is simply not able to hear urgent matters where, human life and dignity are at stake.
Yeah. So it's true that PIL do take a lot of time of the court. Now, this is actually a controversial point because some people have argued that in terms of pure numbers, PIL are like 0.5% of the court's docket, the Supreme Court, which is a very, very small number. So what's the big deal? But actually, I think that's a misleading argument because many of these cases are not really cases that we understand. It's like, for instance, the Forest case has probably had, I don't know, probably 1,000 hearings already. And many of these cases are heard every week, literally.
Yeah, so when you add up all the individual orders, it's not 0.5. It really adds up to a large number.
One forest case might have taken as much as a whole jurisdiction of a particular area. But at the same time, it's difficult to quantify how much time the court spends. It's certainly a substantial amount of time that the court spends. And the thing is that, as we have seen in the last 3 years particularly, the sheer randomness of the court deciding what gets priority in its roster and what doesn't is of course it's completely arbitrary, and certainly the habeas corpus cases are the most unconscionable of them all. And in general that has been the case. The Kashmir gives this, the Kashmir cases of course make it very clear, but there's been a long history of the court being less and less interested in habeas corpus. In general, in negative liberty in the last 3-4 decades, the court has not particularly been interested in civil liberties in general.
Why do you think that is? Is it because it doesn't increase its own power and its own interests in any way, or is it because those are just harder cases? Do you think in the case of Kashmir in particular, and more generally habeas corpus cases, it's because it has to go head to head against the executive of the day, and that's hard to do? So what do you think is going on when it comes to court protecting civil liberties? Because historically, the Indian Supreme Court has a great track record of protecting civil liberties. And recent times, it has completely flipped on that mandate.
So I think, again, like with most things with the court, the key date is like the mid-70s, where it just completely flips. Historically, so I think to sum it in one line, the court moves from being the court of judicial review, a classic counter-majoritarian institution, to being a populist court, the court of judicial populism, where negative liberty is less important for it. So in fact, it's actually, for once we actually have data. And George Gadboy is writing in 1970 in Economic and Political Weekly, actually studied Supreme Court cases for the 2 decades till then, and looked at the sheer number of cases where the court would decide against the government and would strike down statutes. It's quite a remarkable number. I mean, I don't have the numbers at hand right now, but it's certainly quite substantial, and probably unlike almost anywhere else in the world at the time. This changes drastically. So it's interesting because that's this idea that the Supreme Court of India is the most powerful judicial institution in the world, which came about in the 90s, in the early 90s, and it's still, people still talk about it. It's interesting that we don't talk about the court from the 50s and 60s as the most powerful, because that was the time when the court would dare repeatedly to pronounce against the government, to actually strike down statute. Now, interestingly, I haven't done the kind of study that Gadbois did, and I hope somebody does that kind of thing. But of course, the scale is much larger. It's rare to see the court actually strike down a statute in recent times. It's rare to see the court decide against even the government in general in the last 5-6 years. So what's
it switched
going on?
From a court of judicial review and therefore genuinely a check and balance to the executive and the legislature to one that is in some sense complementary to the executive and the legislature, almost usurping the arena of the executive and legislature in its populism. Yeah.
In fact, my dissertation actually, which led to this book, was called Competing Populism. It's competing with that. What I try to argue is that, when Mrs. Gandhi and her Lieutenant Kumara Mangalam used to talk about the need for a committed judiciary, which would not be acting as the counter-majoritarian institution, which would not be stopping the court's populist measures. For instance, the ones you mentioned, nationalization of banks, pre-purchase judgment. These are all very important moves by the court, which were struck down. Very important moves of the government at the time, which were struck down by the courts. So what happens, to my mind, and the judges you mentioned were appointed. Justice Bhabhuti and Justice Krishna are the most well-known, socialist judges who were instrumental in the creation of PIL. These were appointed by Mrs. Gandhi during that period. Yeah. If I'm not wrong, Justice Bhabhuti was actually appointed after the supersession of judges. He was one of the judges who was appointed.
You're absolutely right.
So this is obviously a highly politicized moment in the history of the judiciary, and this is not a coincidence. So what we're seeing is that what I argue is that it does lead to a committed judiciary, that Mrs. Gandhi's challenge is actually successful. And particularly so after 1977. In fact, people talk about the low point of the judiciary as 1976, the ADM Jabalpur case, which is, of course, it is one of the low points.
Also a habeas corpus case.
Also a habeas corpus case. In fact, I keep saying that we exceptionalize that judgment too much. There is far too much continuity from that to now.
I would agree.
So what the judges have been doing since and Minerva Mills, I think, is a remarkable judgment. This is a case where, there are many aspects to it, but a particular amendment which had explicitly given primacy to directive principles over fundamental rights.
This is the 25th Amendment and 31C.
25th and 42nd, 25th Amendment, which Mrs. Gandhi made immediately after she came to power in 71. So the Justice Bhagwati's argument in Minerva Mill's judgment is really, to my mind, it's a minority judgment.
Yes.
There's a lot of background perhaps one needs to give for this, but he actually argues that directive principles can be given primacy over fundamental rights, contrary to the majority judgment. And what I would argue is that actually is what happens in the 4 decades since then.
Yes.
Although it's a minority view, but the logic of 31C is where the court starts heading from that point onwards.
And there's a twofold move here, right? First is directive principles become justiciable and enforceable,
right,
which was never the original intention of the constitutional framers.
Right.
And second, once they become enforceable, in the moment of a conflict between fundamental rights and directive principles, fundamental rights no longer have primacy.
Absolutely.
And the original challenge was that this shouldn't be the case.
Right.
And Minerva Mills opens the floodgates,
right,
and restricts the case of fundamental rights primacy only to Articles 14, 19, and 21.
Right.
Which is also now sort of, become very loosey-goosey.
Right.
But it really opens the floodgates in that sense, right?
Right. In fact, I argue that directive principles from being the only non-justiciable parts of the Constitution become the only justiciable parts of the Constitution. Because everything else is viewed through this through the lens of this chapter.
And a lot of the directive principles have now made their way into fundamental rights
absolutely,
through Article 21.
Absolutely. In fact, I also argue, I mention it, I think in chapter 4, is that at this point, 21, which reads as no person shall be deprived of life or personal liberty except procedure established by law. I think everything else is in 21 now except for that
due process. Right?
So you could have all kinds of rights being read into it except for its literal, what it's supposed to cover. So that's where we are. And yeah.
So now going to the most uncharitable part of my view on what's happened is not just the judges rewriting the rule book, or in some sense throwing away the rule book, but the court has used the PIL mechanism to become a self-appointing court.
Right.
And this, of course, requires a little bit of background. Originally, Article 124 was required to appoint judges to the Supreme Court, and there's a similar provision for the high courts. And that had the word consultation in the text of the Constitution, where the executive and the senior members of the judiciary would have to consult each other before choosing the next set of judges. And this word consultation has been completely reinterpreted in a way that the appointment procedure, which is in the original text of the Constitution, has nothing to do with the way we appoint Supreme Court and High Court justices today. So after the first, second, and third judges' case, the way we appoint judges is through the collegium system, where the Chief Justice of India and 4 of the next 4 senior judges form a collegium. It's a completely opaque process. They are the ones who make nominations. They are the ones who make selections. It's a black box. No one knows why a judge was elevated or transferred or appointed. And any attempts to change that, which happened with the constitutional amendment for the NJAC, which is the National Judicial Appointments Commission, and the following NJAC Act, was also struck down by the court.
Right.
And today it's appointed by a memorandum that was written by the court and vetted by the executive. And we seem to have a bizarre move where we've used the enormous powers that the Supreme Court gained through the PIL procedure, and then it's used it to insulate itself from any external oversight. What do you think happened there, and how do you think they got away with it?
So,
It's a very strange court. I don't know any other court in the world that operates like this.
So I would say it's actually there from the beginning. So one of the first important PIL cases which actually programmatically enunciate the idea of locus, dilution of locus standi is the S.P. Gupta case, the first judge's case. So it's funny that 980, one of the first big PIL cases, is actually about transfer of judges. It's about a Supreme Court lawyer called S.P. Gupta filing a a petition which is treated like a PIL, challenging the transfer of judges. So it's been there from the beginning, and by the 90s, the court had enough political capital to give a judgment, which it does in 94 on as you mentioned about
SCAOR versus Union of India, which is the Supreme Court advocates on record. It completely redoes the collegium system.
Absolutely. Now, there are two aspects to this collegium business. One is, of course, to look at whether it has served its purpose in terms of the collegium. Has it led to a better, higher judiciary in that sense of whether it has led to more representative, higher quality, etc. And there are a lot of people who have differing views on it, and representation is certainly would be highly contested whether it has led to a more representative judiciary or whether it's a higher quality. Again, it's highly debatable and it's very difficult to judge that. But the second aspect to my mind is more troubling, which is this is of course a well-known judgment, a spectacular one. The court decides that it will appoint itself from there onwards. So it's an amendment which the court does of the Constitution to serve its own purposes. And what is the expressive function that a judgment like this brings about? That the court is no longer bound by the Constitution, and because of some other higher purpose, let's say, it can actually go beyond the text of the Constitution. And it has actually done so with regard to other aspects of its powers, whether it be the power to what's called to complete justice in 142, or contempt powers, or review powers, as we are seeing now in the Sabrimala case with regard to the question of religion and access to religious spaces, the way it has gone about interpreting review powers. In fact, one of the arguments is that since it's a PIL, there's no limitation with regard to review powers. So what has this led to is that the court increasingly feels that as long as there are certain positive results that come out of a judgment like this, it's okay to just sidestep the text of not just any law, but the Constitution itself. Now, this is extremely troubling, and it has led, to my mind, it has led to the institutional impact of it has been extremely,
corroding.
Yeah,
corrosive.
Is the correct word. Yeah.
You raised a very interesting question, which is that the Supreme Court believes it is no longer bound by the Constitution, right? And the worst, most egregious form of this is in the self-appointing nature of the court. Right. It has not just reinterpreted 124, it has rewritten in some sense a constitutional provision which it doesn't have the authority to do. Right. I would extend that and say the Supreme Court, at least in recent times, also doesn't apply its own rules to itself.
Right, yeah.
The most immediate case that comes to mind is the Vishakha ruling,
right,
where the Supreme Court actually legislated from the bench, and it's set up way before the Me Too movement or any court in the world, or even the legislature in India and many other parts of the world. It actually created guidelines on sexual harassment in the workplace.
Yeah.
And those guidelines eventually formed the basis for the statute that was passed in Parliament. And when it came to a sexual harassment complaint against one of its own members, actually its most senior member, the Chief Justice of India, Justice Gogoi, suddenly none of the Vishakha guidelines were followed.
Yeah.
And neither in spirit nor in letter, the committee that was formed to address the complaint did not comply with the Vishakha rules. And it was a really bizarre case where the court just decided, all its members were complicit in this, not just the Chief Justice of India, but the court decided that none of the rules that apply to any other institution in India would apply towards constraining its own behavior, maybe because it's a force of greater good or something like that. But to me, it seems like the most dictatorial, self-serving move. This is a classic move of dictators and bad monarchs.
Absolutely. No, this is an astonishing case, even by the court standards. The way it went about this so-called inquiry was really, followed no rules. And the most astonishing aspect was the fact that Suamoto started a PIL actually, just the day after the complaint was lodged. It's on a Saturday, if I remember right. The court, including the Chief Justice himself, who was directly accused in this case, along with two other judges, sat in a case which is called INRI. Was it threatened?
In reference to a matter of great national importance or something like that.
Right.
And the matter they were looking into was meddlesome complaints to diminish the stature of the judiciary.
Absolutely. So this kind of thing can only be available possible in a post-PIL judiciary. And of course, you may say that there are obviously many problems with this. The fact that the judge who was directly accused was himself judging in his own case,
which has happened before many times.
Right. And a second thing is that eventually the order that came did not bear his name, which was also bizarre.
And it assumed a negative outcome of an ongoing sexual harassment inquiry before the inquiry was conducted.
Absolutely. So this is, I mean, there can be no way to justify it. And only a court which has absolute contempt for procedure and it's a highly elevated view of itself could even think that it could get away with it. I don't think it has gotten away with it, because I think the public view of the judiciary has certainly been shaken by, if not by anything else it has done, certainly by this case. But I do think that the court has always had double standards for what it does. For most elementary aspect, for instance, Article 32 allows for any Indian citizen to approach the court directly with regard to any violation of fundamental rights. The court, whenever it wants, it refers any such matters to High Court, saying that you should go to the High Court first. Now, there's a clearly mentioned provision in the Constitution that you have a right to avail this remedy, but the court decides it does, and whenever it decides, vice versa, it decides. Now, so what's the interesting thing about this court is that actually we can talk about its relaxation of rules and all of that and informality, but whenever it wants, it can become ultra formal and ultra technical. Yeah. So that has always been its ability to change the rules in whenever
as
it
suits
fit.
It.
Exactly. So this is, the Vishaka case, there are other aspects to that. In this case, I have to say it's, even by the court standards, it's been amazing. It's been astonishing to watch.
So how does one roll this back? And there are two parts to my question.
Yeah.
So one, I've said that the court needs a sort of Ulysses pact, right? The court needs to tie its own hands.
Right.
For two reasons. One, if it's truly the elevated institution that it is, it must set the example. But more importantly, because it will not allow anyone else to tie its hands.
Yeah.
Anytime there has been an attempt by the executive and the legislature to discipline the court or to streamline this mechanism, it goes back and invokes the excesses of Mrs. Gandhi during the emergency and says that is interference and it is a threat to judicial independence.
Right.
And we can't possibly have any involvement of the legislature or the executive in appointment procedure or transfer procedure or anything at all.
Yeah.
So in this kind of a world where the external branches of government are not allowed to tie its hands and the judiciary won't tie its own hands, how do you think this beast can be rolled back? How do you cut the heads of the Hydra?
Yeah.
Right? It's a hard question, I understand, but where do you think is the starting point to think about this problem in terms of judicial reform?
The one positive thing that has happened in recent times has been the emergence of a culture of criticism around the court, of the court rather, in the last maybe decade or so, especially the last 5 years or so. And that, I think, is the one positive development. The legal academia had, in a sense, been complicit in all the pathologies of if Indian Indian judiciary is also reflected in legal academia. But I think the last 5 years or so has seen an important change that finally we have this culture of criticism emerging. And there's sometimes devastatingly so, and that most of it deserved, in my view. So I think that's one. The kind of perhaps there is no short-term solution to this. We're talking about a very long haul where perhaps the eroding legitimacy of the court that, for instance, the sexual harassment case that you mentioned, and there's so many other instances, what's happening in Kashmir, what's happened in so many instances, they're really in Assam, and the role of the court has been so dubious that perhaps that will have its long-term impact. Though I have to say that the difficulty with that is that India really doesn't need a judiciary which actually practices judicial review. So what has happened is that the delegitimation of the judiciary, and it's being seen through such a cynical lens, which is, in my view, mostly deserved, has its cost that India really deserves a counter-majoritarian court. It really needs one. And this omission that the court has been, party to for the last 4 decades is really the onslaught on civil liberties that we see in India on almost every important. The interesting thing is that Indians are mostly quite cynical about almost all political institutions, except for the judiciary till recently. So maybe this increasing cynicism will lead to a certain kind of churning, but it can also lead to devastating results in terms of the fact that when authoritarian government, a popularly elected authoritarian government, wants to pass laws which are violative of civil liberties, all we have is the court. And of course, we have, popular constitutionalism has emerged in a big way in recent times, and that perhaps is another avenue in which we could see rapid change, that the court is not the final word on constitutionality of statutes, etc. If the court doesn't do its job, there are other. But that's a very difficult path, and I mean, there are no easy answers, frankly. So, yeah.
Absolutely, there are no easy answers. I have a couple of other less serious questions. I'm very curious about your background because you're trained as a lawyer and you're also a trained anthropologist, and your work is in legal anthropology, which is a phrase we don't hear of very often. And now you're back to teaching at a law school. I'm just curious about your sort of professional and intellectual journey.
Yeah, so mine has been a bit of a curious journey. It's a kind of a self-chosen peripatetic academic. I graduated in law from National Law School, Bangalore. I worked for trial lawyers in Delhi for a year, mostly doing criminal law. And then I went for a master's in law at SOAS in London, which is where I got exposed to the entire world of social science writings on law. In National Law School, which is the 5-year law degree, I had done courses in history and in political science, etc. So it had been exposed a little bit to other disciplines. But SOAS is really an exciting place in terms of work going on in South Asian history, South Asian anthropology, for instance. My dissertation was actually on modern legal history. And so for me, it really opened my horizons in a completely new way. And also, I was exposed to people doing very interesting works on law outside the legal discipline. I was reading Partho Chatterjee, Mahmood Mamdani. So legal history at the time seemed like a particularly interesting area, also legal anthropology. And so, after the master's in law, I clearly enjoyed that experience a lot. And I wanted to continue in academics, but the option was whether to continue in legal academics or, doing a PhD in law or in social sciences. And it seemed like that was a much more exciting place to be at the time. A lot of interesting work on legal history was happening in anthropology. So people like Anupama Rao, Partho Chatterjee, Mahmood Mamdani, Elizabeth Povinelli, Brinkley Messick. So, it was clearly a, embarrassment of riches at the time in Columbia University. It still is, of course. So that's where I went. And obviously, I didn't really know much about what the American experience would be like, because I'd never really been to US, and the American grad school experience is a very different one from what I had been exposed to till then. So, of course, I was doing coursework in anthropology for 3 years. So, legal anthropology as a discipline also I was exposed to the first time. And then I later realized that the Columbia version of legal anthropology is a very specific one. It's much more of a historical anthropology approach, inspired by Michel Foucault and his particular methodology. My supervisor was Brinkley Messick, and my chair was Partho Chatterjee. These are people who are really influenced by Michel Foucault's work. That was the approach that I was also trained in. My fieldwork, which my PhD was on PIL, which resulted in the book. And when I came for fieldwork, actually, I also spent some time as a fellow at the Center for Study of Law and Governance at JNU, Jawaharlal Nehru University,
Yes.
which is where I taught for the first time a whole course along with Pratiksha Bakshi, who's a well-known legal sociologist here. And it was very interesting to co-teach a course with her because her training is very different. So she's very much a legal sociologist. The term itself tells you that there is in India, what's called anthropology, in US is really called sociology here. She studied in Delhi School of Economics here and did sociology with Veena Das, probably one of the most well-known sociologists in India and anthropologists in US. That was a very different kind of legal anthropology that I was exposed to by her. And through her, a lot of other scholarship which is coming from the US, in fact. So legal anthropology I found was a particularly useful way to study PIL, in particular public interest litigation, which is what my book eventually came to be about.
And this is more about your own production process. How does a legal anthropologist really work? What do you do on a day-to-day basis, right? So what is your writing process? What is your evidence collection process? So if you can just tell us a little bit about that.
I'll talk about how this book came to be written. I mean, how it came to be researched, really. So think about the principal methodological means that anthropology studies any phenomenon is what's called an ethnography, where, we're talking about qualitative empirical study of a time and a place, and done through field notes, what's called field notes, basically, a form of diary writing. So the father figure of anthropology, a man called Malinowski, had famously a diary, which had its own controversy around it. But so this thing called ethnography as the principal methodological move that anthropologists makes is what we do. So it was interesting for me because I was also a lawyer, so I would literally. I would be dressed as a lawyer and carry a lawyer's diary and use the lawyer's diary and use that to basically discuss. Observe. What's called participant observation. That's what supposedly our technique.
So do you collect all the details first and then begin the writing process? Do you write simultaneously as you do the ethnography?
So ethnography, literally ethnos plus graphos. So ethnos is a community defined by place and time, and graphos is writing. So of course, it's eventually a form of writing that we are doing. But when we're writing field notes, we're already doing some writing. So when I was doing this research, I was doing this for almost 30 months, and it's a very long time. And the book is actually it's a small part of what I spend my time researching. I still have enormous amount of my field notes and materials that I collected. So in that sense, it is really doing this over a period of time, and by the end, the writing has its own alchemy. That's what anthropologists believe. And
so research and writing is not separate,
right,
in that
absolutely.
sense.
I've tried hard to not make it a legal academic book. I mean, of course, it's very much about legal technicalities as well, very much so. But I've tried to write for the general audience because I think this topic is such that I think PIL is something that concerns most Indians, unfortunately, and I try to write in an accessible way, which is not so common in my discipline, I have to say. But I've tried to do that. Absolutely.
Just more curious about you personally. Do you write every day? Do you write at the same time of the day?
So writing is the most difficult thing in my view. I don't know how people talk about pleasure of writing. I mean, writing I find very, very difficult. I'm not very regular, to put it mildly. I mean, anything distracts me. And of course, now in the world of social media and internet, obviously, is the easiest thing to be distracted. So I wish I would say that I could say that I was a regular writer and keeping a journal regularly. When I'm researching something actively, I do, but ordinarily not so much. Anything distracts me. So it's one of those, you have to lock yourself in a room and try to. And of course, I am actually a binge writer, which is not something I recommend to anybody. Once I have done what I think is adequate research, and once I think a fairly clearly formed idea, I just write it. Just so at that point, so it comes out like that. So it's really and I'm very bad at deadlines. So I'm really not not somebody anybody should at all follow. But for me, it is like when I feel like I know enough about it that I can put it down. That's what I do, actually. I eat a lot. I keep taking breaks to snack. That's what perhaps that's, to reward myself for having written a few, few sentences or few paragraphs. I would take a break and,
there are lovely movie references scattered all over the book. So do you watch a lot of TV shows and Netflix and movies, or, sort of what is the distraction outside of writing?
So I'm a big movie buff. I've been a movie buff forever, since when I can remember. One of my favorite, one of the best feedback I've got on my book is my friend who's actually a film theory person. She said she read it from cover to cover.
So what are some of your favorite legal movies, or even PIL movies as a subset of legal movies?
Well, PIL movies, There are quite a few. I mean, I talk about this movie called Jolly LLB,
Jolly LLB is
one
in
and
the
two.
book.
I really enjoyed those movies. Of course, their representation of PIL is highly problematic.
But the judge is very entertaining in both those movies.
Absolutely. And I really enjoyed them. Court, of course, is a great
Yes.
movie, especially for teaching.
But it's very Kafkaesque. It doesn't leave you happy like Jolly LLB.
Jolly LLB,
It's
certainly.
quite depressing, like the PIL story.
There's this film, this art house kind of film called Ship of Theseus.
Yes.
Which came a few years back. There was a particular part which is all about the court process. Of course, there are quite a few. Interesting thing is that actually India has very little courtroom drama going on in cinema relative to
what it used to have in the 70s.
Yeah. And especially compared to US or some place like that where, the genre is such a huge one. There's nothing like Law and Order or even any police procedural dramas. So that's an interesting thing considering like...
Culturally, you're right. That's an interesting thing that we don't do that.
So considering our lives are so suffused with legal reporting, you pick up any Indian newspaper any day, there would be as much writing on the court as on any other institution, if not more. I watch a lot of Netflix, too much.
So what are you binge watching now?
Well,
or what can you admit to binge watching now?
Well, recently I saw Marriage Story, which of course was also a courtroom.
Really lovely.
Lovely movie. In terms of legal drama, I really like the O.J. Simpson, the 10-part...
yes, the American Story.
Story. That's really brilliant. In my view, probably one of the best TV adaptations of legal process that I have seen. That was quite incredible. But yeah, so somehow I wouldn't say that Indian TV around court, around legal process really has done justice to what it deserves. So but of course this is changing fast, and hopefully court is certainly one that I would highly
This is the
recommend.
Marathi movie.
Yeah.
Yes,
that
I also strongly recommend Court.
Yeah.
Thank you so much. You've been very, very generous with your time.
Thank you.
Thanks for listening to Ideas of India. If you enjoy this podcast, please help us grow by sharing with like-minded friends. You can connect with me on Twitter at @srajagopal. And here's a sneak peek of my next conversation with Shreya Iyer on the economics of religion in India.
The economics of religion is a new and fascinating area of economics research, where economists are applying methods from economic theory as well as statistical tools to evaluate the role of religion in society. So here they're looking at the characteristics of religious communities. They're looking at the way in which religious organizations evolve over time. And the reason we're interested in these behaviors is because we think that economists do have much to contribute to broader debates about religion in society, as well as related issues such as religious conflict. When we're thinking about the economics of religion, we use what is essentially called the rational choice approach. And that means we're thinking of a market for religion, just as you think of other goods and services. So there's a demand for religion that comes on the part of adherents. There's the supply of religion that's being provided for by religious organizations, and you're trying to match the demand with the supply. And this is what creates the market for religions. And this is where we think economists have something to contribute, because in general, economists do look at the evolution of markets of different kinds.